On PM Express tonight, a conversation about Parliament versus a special prosecutor, an attempt to fix a tenuous relationship that is becoming one that has left the two arms of government in perpetual conflict. It started last week, it continued today at the High Court. We all know it started when Ayariga was slapped with tax fraud and other charges by the special prosecutor. Now, he's a member of parliament. He has immunity. Members of parliament will argue, but the special prosecutor says, well, that shouldn't be an issue for him to deal with. Now, the speaker, on two occasions, wrote to the High Court. The High Court is hearing this particular matter, by the way, asserting Ms. Ayariga's immunity. And the speaker, in the latest one that the speaker had written to the registrar of the High Court, the financial division, he makes the point. He quotes three different provisions in the Constitution, including the very controversial one, Article 122, that talks about contempt of Parliament. If you act or do anything that jeopardizes the work of Parliament, it could be contempt of Parliament. Does this suggest that? Is the speaker suggesting in that letter he wrote to Parliament that the actions of the court in demanding that Ayariga appear before it to answer these charges, regardless sometimes of the timing and the constitutional provisions, may amount to contempt of court? We'll try and settle that particular conversation. What was the purpose of including the particular clause in the letter to Parliament? But guess what happened? On both occasions, the court rejects the speaker's ruling. Today was the latest one, in spite of expanding the scope of the interpretation. And remember that the speaker, in his first ruling on this matter, had just restricted himself to other provisions, just simply dealing with when the member of parliament is on his way to or from parliament, you cannot invite him to serve as a witness in matters that relates to, say, criminality, etc. But today he added the different clauses. In spite of that, the judge still rejected the speaker's ruling on this matter. And in fact, if you listen, pay attention closely to what the judge said, she and the court only reserve the power to dictate when Ayariga will appear before it. And there's a portion of the ruling where she suggests that the court will not act in a way that appears that it's inferior to that arm, to the other arm of government. That is a very interesting debate and tussle between these two arms of government that we'll try to get to the bottom of on the show. Ayariga is one, by the way, of 8 members of parliament that the special prosecutor is interested in, that, you know, in as far as investigations are concerned. And from what the special prosecutor himself had said, he's written to the parliament asking for these individuals to be released for probing, for interrogation, for questioning on these other matters relating to corruption. And that alone is an very interesting matter to probe as well, because we also know that apparently the speaker and the leadership had invited Martin Amedu to parliament to have a discussion on this matter to find an amicable solution. If you read Martin Amedu's epistle, he says he will not bow to that pressure. He won't do that. He will allow the court to handle the matter. But you know, Parliament invited him over these matters, and this was after the special prosecutor notified Parliament about his intention to get all these MPs, you know, to come in for questioning. Amedu writes an epistle, and this is an interesting one, alleging a conspiracy against him, a bipartisan conspiracy. In one instance, suggesting that there's a bipartisan conspiracy to frustrate him, even get him out of office. And he's vowing that he will not kowtow. In fact, at one point, he assures the public that he will not quit his job. He will not leave his job because of the pressure he's getting from members of parliament. But is there a bipartisan conspiracy against him? That is the question we are asking tonight. We'll ask the member of parliament who will join us shortly, and some other legal brains who have also been chewing on this subject all day since last week as well. Stay with us here on PMS. When we return, we'll dissect the matters. You're live on PM Express tonight. My guest in the studio is Inusa Fuseni, who is the Member of Parliament for Tamale Central. He's also the ranking on the Constitutional Legal Affairs Committee in Parliament. Thank you, Honorable, for your time here on
Thank you, Evans.
on PM Express. Also joining us via Skype is private legal practitioner Martin Kpebu. Will join us with his thoughts also, and Bright Soul will also join us via Skype. He is a senior research fellow at the Ghana Anti-Corruption Coalition. Will also join us on this all-important conversation. A lot has happened, Inusa, on this subject. But even before I come to that, there's a bird whispered to me that your primary is next month.
Yes, I mean, the primaries will take off or come off before August. Yes.
Okay, before August. Is this something that you are running? Are you apprehensive?
No. I've announced my retirement from Parliament.
Okay.
Yes.
So this is going to be your final?
This is going to be final.
Okay.
December, January 7th will be my final day in Parliament.
Final day in Parliament. Are you?
Or January 6th, actually.
Yeah. You have nostalgia already? I mean, you're looking forward to, becoming honorary citizen with that immunity?
Yes. I'm looking forward to that. Really eager to move into private life.
We'll start serving you processes and won't think about your constitutional immunity.
Doesn't matter.
That doesn't scare you?
Doesn't scare me.
At all?
At all.
Okay. Question. Martin Hamidu wrote an epistle. There are three different things happening, and there's a lot happening on this. It's really unprecedented, the way the two arms of government seem to be clashing on this matter. Martin Hamidu suggests that he's written to invite, or he's interested in more MPs. He says there are 8 or so of them that he's interested in. Are you one of them?
No.
You're not one of them.
No.
Okay. What do you make of his posture on this? In fact, in his epistle, writing on the back of all that has happened in the Mahama Ayariga matter, he says that there is a bipartisan, I want to quote him for the avoidance of doubt, for those who haven't read it. He suggests that there is a bipartisan attempt to sort of muzzle him. In part, he says it only enables the creation of an artificial bipartisan smoke screen for purposes of unduly delaying or running away from justice for a category of suspects accused of commission of corruption. That's not the only part in his long epistle where he makes this reference to bipartisan conspiracy. In another part, it says, any appearance of a bipartisan mounting of pressure on the decision-making process of the Office of Special Prosecutor will send a wrong signal to the international community. He also says that, he has written to Parliament, and should there be any bipartisan agenda for publishing certain truths, the public should be told upfront. Is there a bipartisan agenda in Parliament against the Special Prosecutor?
Evans, I think that it's appropriate for me to first of all say good evening to you and your listening public, and to wish them well this evening, and to state categorically that I am unaware of any bipartisan moves to get at the Special Prosecutor. Mind you, I played a very instrumental role in fashioning out a legal regime that would not violate Article 88 of the Constitution and also secure some level of independence for the Office of the Special Prosecutor. We did that because all of us are united in the objective of fighting corruption in this country and corruption-related offenses. And Parliament, as an institution, was key in ensuring the realization and actualization of the manifesto of the MPP, the 2016 manifesto of the MPP, which spoke about the establishment of that office. Now, without Parliament lending its support to the establishment of that office, I'm not sure Martin Hamidu would have been appointed. So I fail to see how Parliament could lend its support wholeheartedly to the creation of an office and the fight against corruption, then turn around to in any way impede, inhibit, and prevent the operationalization of that office.
Because now he's coming after some of your colleagues.
No.
Who he calls suspects.
Parliament
in the Commission of Corruption
never
Crimes.
said that Martin Hamidu should not come after members of Parliament. Parliament has never said that. I am aware that any time Martin Hamidu requires the attendance of a member of Parliament to his office to answer or assist in investigations, is written to Parliament, to the Speaker, to Parliament through the Speaker, and the Speaker has always released the members of Parliament to attend upon Martin Amidu to assist in investigations. So I can only say that probably the bipartisan, the alleged bipartisan conspiracy to get at him probably is a figment of his own imagination. What the Speaker must be understood to be saying is his interpretation and understanding of Article 117, 118, and 122 of the Constitution. And he says that the combined effect of these three articles appear to give members of Parliament a certain level of immunity when Parliament is in session. And that in any attempt to get members of Parliament to assist in the investigation, or in the event that members of Parliament are sent for prosecution, one should be mindful of the privileges and immunities granted members of Parliament.
Yeah.
He has, the Speaker, has said that, look, don't just read these immunities and privileges in vacuum, if you want. Because if you have a capricious executive, they can use the prosecution to thwart the performance of the work of Parliament, especially where we have a slim majority in Parliament. The executive could use prosecution and investigation as a means to dissipate the minority to be able to get its way through. And so we should look at the intendment of the immunities and privileges granted members of Parliament vis-a-vis the work of Parliament in holding executive accountable. And in his reading of that, he thinks that members of Parliament must attend court and answer to questions, charges preferred against them. Members of Parliament have a legal responsibility to assist in the investigation of cases brought against them. But in doing so, investigators must be mindful of these immunities and ensure that they don't take members of Parliament outside Parliament when Parliament is in session, because in his view, it could be an interference in the work of Parliament as captured in Article 122 of the Constitution.
Now, but that is interesting. But just on the Martin Amidu's concerns, he discloses and that apparently the Speaker and the leadership had invited him to come have discussions after he issued this invitation to Martin, the Mahama Ayariga matter came up. And that he doesn't see the need why that meeting was necessary in the first place. He says in that meeting, the Special Prosecutor made it clear to the discussions with the leadership of Parliament that no provisions of the Constitution referred to by the Honourable Speaker, which you just referred to in his invitation letter, and submission at the meeting were applicable to members of Parliament charged as accused person for the crimes of corruption and put before court of competent jurisdiction for trial. He was clear in his mind that if you put all these subtle pressure, why is Parliament interested in inviting him to come and sit and discuss on a matter that is purely legal? He's simply doing his job. Why was that necessary in the first place?
First of all, Martin Amidu must know that in Ghana, we are practicing the loose form of separation of powers. It's not a strict separation of powers. And that is why you have members of Parliament being part of the executive. Now, loose separation of powers is intended to ensure the proper functioning of government. So you remove friction within the various arms of government. And so the invitation to Martin Amidu to appear before or meet the Speaker and leadership of Parliament was to ensure that the smoothing the rough edges of the performance of his functions and the work of Parliament, and not at all to ask him to drop the charges against Ayariga. No, nobody. And the Speaker had cause to say that. That the invitation was never intended to tell him to drop the charges. Just be mindful of the fact that Ayariga could attend court, and he has to attend court to answer to those charges, but attend court in such a way that it doesn't impede his representational capacity or his immunities, or affront his immunities and privileges granted him by the Constitution. And I don't think that was asking too much. And so to write an epistle to postulate that that invitation to you was an egregious invasion of your independence as a special prosecutor is far-fetched. No, it was not. And in that epistle, I've read it. Matanamidu is saying in one vein that the invitation and the submission that the Article 117, 118, and 122 granted Ayariga some immunities, and that those immunities ought to be respected, was a matter for the court to decide.
True.
He says that.
Yeah.
And in another vein, he makes a pronouncement on that.
Yes. That's his view.
So how do you approbate and reprobate?
No, but his view is that you guys are wrong.
So he was
verdict,
perfectly within his right to have said, look, the course list has been prepared by the court. It is the court that fixed the 4th of June for Ayariga to attend court and answer to those charges. The court having given us a day to appear, I was no longer seized with the matter, and the matter was in court. And even if he was sympathetic to the view of Parliament, he could do nothing about it. So why do you go writing an epistle about a matter that you yourself have said lay within the bosom of the court? Why?
I want to bring you your colleague, Martin Kpebu, my paralegal practitioner, who's joining us on the telephone line right now. Mr. Kpebu, thank you for your time here on PMS Rest. Can you hear me? Mr. Kpebu, can you hear me?
Yes, I can hear you.
Fantastic. Thank you very much. Before we go, there's very interesting development. This started last week. It hasn't stopped. I spoke to the majority leader today who believes something must be done to deal with this matter permanently. There is a suggestion tonight from the lawyers of Mahama Ayariga that this matter will end up, they're going to the Supreme Court to seek an interpretation on this matter of the immunity. Before we come to the legal matters, though, is the special prosecutor right to make the point that he makes in his letter that he's written, that this matter of the speaker's position on the immunity, the speaker is wrong? And I want to read it. It said the special prosecutor made it clear, because there had been a meeting between himself and the leadership of Parliament, at that meeting, that no provisions of the Constitution referred to by the Right Honourable Speaker, and the provisions have been articulated here by Inusa Fuseni, but just for avoidance of that, I want to cite them. Article 117, Article 1181, and 122. It says none of these provisions referred to by the Honourable Minister in his invitation letter and submission at the meeting were applicable to members of Parliament charged as accused persons for the crimes of corruption and put before a court of competent jurisdiction for trial. What's your take? Is he right?
No, I don't share in the special prosecutor's interpretation. No, Evans, you see, if you look at 117, that stipulates that no criminal or civil process shall be served on a member of Parliament. It has a deeper meaning than you see on the face of it. You see, service of a process on a member of Parliament could be the commencement, or active commencement of a case against the member. So if the Constitution says don't serve him, and the document that you intend to serve him is one that has implications that require him to answer, that's to put in a defense or appear in court to defend himself and all that, then it means that you'll be breaching the Constitution. So the service of the process, let's remember, Evans, what is not clear to many lay people is that there are some processes. When you serve it, that is the beginning of a case against an MP. So when you serve it, he has some obligations to perform. Otherwise, a judgment will be given against him. So let's say the criminal one, when he's served with the charge sheet, okay, and facts and all that, and hearing notice to appear in court, if it doesn't appear, then a bench warrant could be issued against him. They say, yeah, so it's not just the service. The service comes with some implications. And we read the law as a whole. Okay, so you read all the provisions together. So if you look at 117 put together with 122, the one about don't impede a member in the performance of his duty, you can see a clear intention by the lawmaker to, that's the Constitution, or the people of Ghana, I mean, putting it broadly, to make sure that parliamentarians are not unduly inhibited in the performance of their duties. And please, let's quickly add this. The immunity is partial, it's not total. You see, Mahama Ayariga went to court, he's been asking for the sittings to be conducted on Mondays. I think that is reasonable. And this is not the first time. I think the speaker also referred to the precedent, the case of Abu Dhabi, where the sittings were on Mondays. And also, I don't think this trial judge has foreclosed sittings on Mondays. So for me, I just think that we should take it one day at a time. Yes, sometimes the epistles could look like there is there's a war, so to speak. But actually, this is a storm in a teacup. I don't see that there is really a collision.
Except though, and I'll come to some on this, except though, if you see the way this has been handled between the legislature and the exec and the judiciary on this matter, the second time the speaker rules on this, and for the second time he wrote to the court, expressing on the court, I mean pressing on the court to be mindful of the constitutional provisions you have just cited. The court had said, and I want to quote the judgment, part of the judgment that the court gave today. Today we managed to secure a copy of that. And the court said this in reaction to the speaker's letter. The court said, I've taken notice of this. However, in the ruling of this court, that is the last week's ruling, in the case of the Republic versus Hajia Nanchema and 6 others, this court made a pronouncement on whether or not the speaker's certificate issued will be binding on this court, given the fact that the first accused is not being compelled to appear as witness, but as an accused person. Those remarks still hold valid, as there is no such need perceived, save to state that in considering how this case will be managed and the trial conducted going forward, the following will be the guiding principles, and this is where it gets interesting. An accused person has the right to be for speedy trial. It says, while appreciating the very important duty these most respected lawyers are engaged in as legislators, that there will be no situation, to borrow the words of Justice Adinyira in the ex parte Francis case, of conducting the business of the court as though it is secondary to that of counsel or anyone else for that matter, within the confines of the proper exercise of judicial discretion. To put it mildly, the court is saying, we will not, only us have the power to determine matters that the court has to deal with. Not even Parliament. Not even the question of when he comes here. It's only the court that can do that. This is the court's position, and the court agrees with Martin Amidou.
Yeah, Evans, there is a bigger context to the ruling, you say. So sometimes, the judge can only write in so many words, but there's a bigger context. So the bigger context is this. You see, at the last sitting of the court, when was the adjournment? I mean, when was the case adjourned to? They adjourned
Monday.
To
today.
What do you call it? A Monday.
Yeah,
was
today.
That also?
Today, yes, 17th.
Exactly. So for me, that is where we should be looking at. So let's not just look at only the words of the judge, but also the actions. When did she adjourn the case to? Or which date did she adjourn the case to? And that date, it's a Monday.
No,
today.
but so the point is making is that, but the point the judge is making is that adjournments are large, I'm quoting, adjournments are largely within the discretion of the court. An application should be considered with the primary objective of ensuring a speedy hearing. So the point is making is that today is a Monday, but if she decides to set it on a Wednesday, it is still the court's prerogative to do so.
Good. Oh yes, that's correct, and we cannot challenge that. So
why can't you? Here's the point. Sorry, why can't you challenge that when the speaker's letter quotes 122, 181, and 117? That says you can't do that when the man is on his way. He's going to perform parliamentary functions.
Perfect, Evan. So that is it. So you know what will happen? It means that for each adjournment, the judge would ascertain whether Parliament is in session or not. You see, because even remember the last time I was even on news file, there is what we call the parliamentary practice. It's called Eskin. Even in that one in England, where we copied these laws from, they don't grant absolute immunity to parliamentarians. It's partial. So what the judge is saying, she's just reminding everybody, and even in that Eskin book, that is what it is. In England, this let me say, war, so to speak, or let me say disagreement between Parliament and the judges, it took place. Yeah, they also had the same kind of differences and disagreements leading to several court judgments. And finally, they agreed. I mean, the court decisions make it clear that it's for the court to decide, okay? So what the judge is stating is the law. She would decide when the hearing is conducted. But in deciding those days, certainly, she's going to consider whether Parliament is in session or not. That is it. So it means that
let me bring it.
Be accepted. Evans, let me just land this way. What cannot be accepted is that it's not the speaker who decides the dates. So she's certainly the speaker's letter deserves, his ruling deserves some weight. But ultimately, it's the judge who decides. So that's all that she's saying. But in deciding, Evans, trust me, she would have consideration for the matter of whether Parliament is in session or not. So my understanding is that when Parliament goes on recess, then they can have more days for more hearings. But when Parliament is in session, definitely the judge will consider the availability of the MP.
You've seen the judge's ruling today, Yusuf Hussaini. Is that your understanding of it as well?
Well, the judge was just stating the obvious.
Okay.
Because Article 125 settles the matter beyond doubt.
125, what does it say?
It says that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent, and subject only to this Constitution. And so judicial power...
Subject to the Constitution?
Yes, the judicial power vests in the Constitution.
True, but the subject to the Constitution, is it the Constitution that says that you also have...
Yes, subject to the Constitution. So, the subject to the Constitution means in the performance of its functions, it can only be subject to the Constitution. Okay. Okay? And not subject to Parliament. Okay. Not subject to the interpretation of Parliament. And in fact, Article 125 of the Constitution further says that the interpretation, the judicial power of the state is vested in the judiciary. So they have to determine whether or not the immunities that is being claimed by Parliament or members of Parliament is absolute or partial.
So what's the point of the Speaker including Article 122, which reads, an act or omission which obstructs, and this was his letter to the court, an act or omission which obstructs or impede a member or officer of Parliament in the discharge of his duties or affronts the dignity of Parliament or which tends either directly or indirectly to produce that result is contempt of Parliament. He seemed to be suggesting to the court that its actions could be construed as contempt of Parliament.
So Article 122 is contempt of Parliament.
Yeah.
Okay, and finds expression in the standing orders of Parliament. The Speaker's view is that when you read Article 117, that is, no process can be served on a member of Parliament on his way to Parliament, attending to Parliament, or returning to Parliament, or no process can be served on the Speaker, the clerk, or member of Parliament to compel him to attend court, or, I mean, a place outside Parliament as a witness.
As a witness.
Okay? and Article 122, which is an interference. The combined effect is that when a process is served on a member of parliament and impedes the member of parliament from attending his functions as member of parliament, that could constitute an interference. Okay, so the speaker was reading the three provisions together, and the combined effect will be an interference.
Okay, so what he's saying is that he's alerting to the court to be mindful of these.
These matters.
But here's what is interesting. In the judge's ruling, the judge didn't acknowledge. He didn't even acknowledge the provisions quoted by the speaker to say that, okay, I understand what the provisions, and in fixing a date, I will be mindful of your constitutional.
He didn't have acknowledged that.
Should he? Should the judge have?
So when the judge said she's not bound, that's why I said she's sitting in the office.
Yeah.
The High Court judge is
should he
not
have at least acknowledged the fact that these provisions are there, and in fixing, as Martin Kpebu suggesting, that if she's fixing the date, Martin is confident that she'll be mindful of these provisions.
She will be mindful of those provisions, but she need not say that.
Okay, but that's a ruling.
Because that will impact on her independence. Okay, taking extrinsic matters into consideration.
But these are constitutional matters.
Well,
the legal matters.
Well, she's independent in the performance of her functions as a judge of the High Court. And she's not subject to the control or direction of anybody.
Not even the speakers.
Not even the Chief Justice.
Yeah, okay.
Okay? And so well, she could be minded. She could have recourse, or she could be guided by what the speaker has written. But she need not state that. And that's what Martin is trying to explain to you, that you go beyond what she said, and you see her adjourning the matter to a Monday. Why did she adjourn the matter to a Monday?
So she should be mindful of it.
So probably she was being mindful, but she didn't say that. She needed to assert her independence, and every judge will do that. If I join the bench, I will do that.
Okay, so if that is the case, Speaker of Parliament is a lawyer himself, right? Why did he take the trouble to do this ruling and write to the court?
So just saying that, well, can you be minded?
But the court, but as you're saying, the court is already minded.
Yes.
So what's the point of writing? This is the second ruling he's done that he sent to the.
That's the first ruling.
No. There's a first one.
No.
There was a first one last week. That didn't include Article 122.
No. Let me tell you what.
Please tell me.
So Speaker writes to Martin Abidu.
Yeah.
Martin, can you be mindful of Article 117, 118, and 122 of the Constitution? Pursuant to our conversation and discussions. Martin writes back, or Martin in the meeting states that, well, you see, this matter is not sub judice, and I am not seized with authority to be mindful of those facts. Can you address your concerns
to the court?
To the court. So that's why Speaker wrote to the court.
Okay.
Yes. So it is not a new thing. Okay. He was not coming up with a new development. No.
But the ruling that he read on the floor, the first one he read on the floor, you know, last week he read on the second one.
So that floor, the jurisdiction of the speaker was invoked by the submissions of Ayariga on the floor of Parliament.
Okay.
So having raised the matter on the floor of Parliament, not directed at the special prosecutor or the court, but in exercise of his fundamental right to freedom of expression and in pursuant of his of the privileges and immunities granted him by the Constitution, the Speaker was bound to give a ruling.
Okay, so my point is, if what you're saying and what Martin is saying is the case, and the court will consider anyway, then there's no issue. Why would the Speaker feel the need then to write to the court and say, bear that in mind? If not the feeling that the court, prior to that writing, was not bearing that in mind. And so let me write to them to at least let them to bear that in mind.
Honorable Ayariga had not even appeared before court. It is instructive to note that when Ayariga made the submissions on the floor of the House on the 4th day of June 2019, the court had given Ayariga up to 1 o'clock to appear before court. The Speaker, in his ruling, released Ayariga to appear.
Go.
Parliament was sitting.
So that matter should have been resolved.
So the Speaker was even mindful of the fact that he could not compel the court to do otherwise.
Okay, so what's the purpose of, that's my question to you, what's the purpose of the direct letter down to the court?
Out of dignity and respect, out of obedience of the court, respect of the court, the Parliament was just informing the court that the person that is going to be within this charge is a member of Parliament.
No, but but by that time, a certificate, the first time he showed up at the 1 p.m., he went with a speaker certificate.
Yes, the speaker had issued a certificate that he's a member of Parliament.
So that is my point. So that certificate would have then communicated that he's a member of Parliament.
Yes.
And he's doing his work.
Yes.
So why the need then to send a separate one to the registrar of the court?
I've just told you that the speaker's certificate was issued to Ayariga as evidence that he's member of Parliament and
True.
he attended Parliament.
And then the second one?
The second one was directed to the registrar to be brought to the attention of the judge
that
Ayariga is a member of Parliament, and in fixing the court hearings, one should be mindful of Article 117, 118, and 122.
The court knows that.
No, yes, but for the abundance of caution.
No, but so that is why some members of the public believe that you members of Parliament seem to have this entitlement that when it comes to the application of the law, you seem to quickly run under your privileges and your partial immunity, and you're hauling people for contempt. The speaker himself is citing that particular article, that this was an absolute unnecessary move by Parliament to create a big deal out of nothing when the court, as you say, have the right to do what they are doing. There should be no need for this in the first place.
Evans,
how do you react to that sentiment?
Evans, who has told you that rights are given?
The Constitution gives rights.
No, we fight for the rights.
Okay.
So, if Constitution gives you the rights and you fail to fight for it, it will be trampled upon.
Okay.
All Ayariga is doing is fighting for that right.
Okay, but is somebody trampling on your rights, on that right to immunity?
He is within his legal limits to be apprehensive that his rights are being trampled upon.
By the courts?
By the court or by the special prosecutor. He's within. That is how the jurisprudence of rights are developed. You don't just think that because it's granted in the Constitution, you'll be led to the gallows thinking that somebody will respect your rights. You don't do that. You fight for it. At any given opportunity, you assert that right. And Ayariga was just asserting that right. Everybody will, you should assert your rights. If not, you will take it for granted. And so he asserted his right. The court says, look, I will not be bound by the letter from the court. I'm not bound by it. And that's the truism. That's right. But the court might be minded. And indeed, we see evidence of mindfulness when the court adjourned the matter to a Monday. And so, I don't see the farce. I just think that...
But the farce is not... my question actually to you was that. The farce is the creation of Parliament.
It's not a creation of Parliament.
No, but you guys made it the big deal. You were on the floor. The speaker gave a ruling. He gave a second one. He wrote to the court. You created a farce. Meanwhile, the court was simply doing what you've just told me was within his right.
I say the farce is, one, people thinking that we are unnecessarily and without some level of decorum and civic responsibility trying to frustrate the court in the delivery of justice. And I'm saying that is far from the truth.
Okay.
What Ayariga did and what Speaker has done consistently is to draw attention to the rule of law. And this is how things should be done by our Constitution.
Okay.
You choose to ignore it, well, probably, we just heard Ayariga say he will go to the Supreme Court.
Yes, he says so.
Yes, so, and it just makes the administration of this country and the administration of justice smoother. Okay.
Martin, this matter keeps on coming up. I guess this is the first time it's really become, as he says, this fussy. What's your recommendation for how this is resolved?
I think I subscribe to the attempt to go to the Supreme Court. Yes, we should have the Supreme Court pronounce on this for all. Yes, because as I stated earlier, even in England, DS evolved over time. It was not just a one-day event. It spanned over 5 decades, right? Yes. Even, look, let me tell you a story. When it first began, one day Parliament imprisoned 2 judges, okay? Yes, for taking a decision that they thought infringed upon the parliamentary privilege. They called the judges before Parliament and then cited them for contempt. That's Lord Pemberton and then Thomas Jones. They were in prison. There were other interesting cases. So what the point I'm making is that in a democracy, these things happen. We need to sometimes have these debates, these banters, and they help to expand the frontiers of our democracy. So I subscribe to the attempt to go to the Supreme Court for a constitutional interpretation. That would help us.
Thank you very much, Kpebu. He's a paralegal practitioner sharing his thoughts on this. We're going to take a break. When we return, the special prosecutors seem to believe the Parliament's approach to this is hurting the fight against corruption. When they pass the law, is that really the case? We'll delve into that when we return from the break. You're live on the PM Express. It's on Joy 99. It's on the JoyNews channel on Multi TV. Still discussing this controversy between Parliament and the Special Prosecutor on addressing this particular tenuous relationship that exists between the two institutions. There is a sense that Martin Amidu puts out there in his epistle that suggests that Parliament is not as committed to the fight against corruption. And he says in this paragraph that any appearance of a bipartisan mounting of pressure on the decision-making process of the Office of the Special Prosecutor sends a wrong signal not only to the citizens of Ghana, but also to the international community to whom the appearance was given that all citizens are willing to equally submit to investigation and prosecution for suspected corruption and corruption-related offenses. The fight against suspected corruption has to be engaged in wholeheartedly by every citizen and with total commitment as enjoined by the Constitution. Matamidi seems to suggest that Parliament is not engaged in a wholehearted attempt to deal with this corruption, with all this scheming behind the background to get him to shut up.
You see, Evans, Martin Amidu is seeing conspiracy in Parliament when there is none. I mean, his accusation falls within the general disdain of politicians and particularly members of Parliament. Why will he think that way? No one has said that a member of Parliament should not stand trial. I mean, if that were so, his request for a release of members of Parliament would not have been granted by the Speaker. And anytime he writes a letter to Speaker for the release of a member of Parliament to assist in investigations, the Speaker has always acceded to the request. So why will he see a conspiracy, a bipartisan conspiracy, to frustrate the fight against corruption? Why will he see that?
Is there none?
I mean, that clearly is a figment of his own imagination. The Parliament demonstrated its commitment to fight corruption when it passed the law. In fact, it is because Parliament passed the Special Prosecutor Act or bill into law, that's why he was appointed. If there were no law, he wouldn't be appointed. So why would you think that Parliament, and Parliament had to craftily navigate Article 188 of the Constitution to be able to establish his office? Why would you think that Parliament will go to that expense in establishing an office and then turn around to frustrate? I think that Martin Amidu should just work in his office and ensure that the resources, facilities given to him to fight corruption are used for the betterment or the intended purposes for which he was given the resources, and also to help this country fight corruption. No one is out there in Parliament to get at Martin Amidu.
Now, isn't your Parliament's effort to get him to meeting, etc., frustrating that process? I think he believes
Nothing is frustrating the process. Nothing. I mean, if tomorrow Martin Amidu comes to Parliament or writes to the Speaker that he should release a member of Parliament to appear before him for investigation, I think the Speaker will do that. If there is a clause that says a member of Parliament is to appear before court, the Speaker will again release that member provided that the privileges and immunities of that member will be respected by the courts. And so there is no attempt. And no one since this matter broke out has said that Ayariga should not attend court. No one has said that. Ayariga himself has not said that. So why would there be a conspiracy?
Let me bring in Martin. Martin, so there's this anti-corruption angle to this conversation that Amidou is hinting at, that if this particular matter isn't resolved and the way he believes Parliament is going about it, it sends wrong signals that the fight against corruption, at least at that level of legislature, is not as committed. Do you share his fears?
Not based on what you're telling me. So what I'm saying is that, look, Evans, if let's say the criminal trial in respect of Ayariga could be conducted on every Monday whilst Parliament is in session, Evans, that would be very fast, knowing the way cases drag in court. So for me, if they can hold hearings every Monday, it's fast. Yes, it's extremely fast. So I don't see where the attempt to frustrate the fight against corruption is coming from. No, at all. So the most important thing is that, and don't forget, as I stated earlier, when Parliament is not in session, it's expected that there will be more hearings in the week. So that can make up. But Evans, the general tenor of our criminal cases, let's say you have a criminal trial, and it is said that every Monday there is a hearing. Trust me, Evans, from my experience, such a criminal trial looks very efficient. So I don't see sittings on every Monday being an attempt to frustrate the fight against corruption. Not at all. Unless there is more to it that you and I don't know.
And thank you very much, Martin Kpebu. Thank you. I'm grateful that you joined us. And that last point, I guess, is Martin Amidou's suspicion that there's something more to all this. Now, that meets the eye. I know you disagree. You disagree with him fundamentally, but the man believes that. And there's a reason why he's writing this episode. I mean, so you believe that the Supreme Court is also the way to settle this once and for all?
Yes, I think so. I think so. I mean, our law, our jurisprudence on the remit of the privileges and immunities can only be better elucidated, better established if the Supreme Court makes a pronouncement, because all other courts will be bound by the decision of the Supreme Court.
Okay, and we've already heard that the lawyers for Mahama Ayariga had already said that they will be doing that at the Supreme Court on this very matter. So see how that pans out in the coming days. I'm grateful that you joined us.
Thank you.
And next year you'll back to...
Not next year.
Oh, next 2 years.
Next 2 years.
Yes, you'll be back to me without immunity.
Yes. Yes. I mean,
are you supporting anybody though? Now that you are going.
No, I'm not supporting anybody. I'm just leaving the process. I want the process to produce an MP and they can. I mean, a candidate.
You know what happens in politics when you are stepping out? You bless somebody.
No. I mean, you don't need to bless anybody.
You have, but you won't share.
That's not a traditional stool. That's not a traditional stool.
But yeah, I know. But politicians do that.
No. Okay, I'm a different politician. I don't think that I should do that.
Okay, you're not blessing anybody.
I'm not blessing anybody.
Okay, but you must have had you're out of politics completely, or you're going to stay?
No. Out of legislative elections. I'm not going to go for any legislative elections.
Yeah, you're going to probably stand for the higher one day.
No. I think
that
I will have opportunity to support my candidate John Dramani Mahama in the 2020 elections. Then thereafter, I'll continue to engage in the politics of this country as
maybe as possible president.
As an NDC member, not as possible president, as NDC member.
You don't want to be president. I want to be president. You don't want to be president.
I'm saying that I have a president now, and the presidential candidate is John Dramani Mahama. And my attention
when he's no more.
When he's no more, the system will produce a person.
If it's you,
the system will produce a person.
That person might be you.
The system will produce a person.
Thank you very much, Elisa Husseini. Enjoy the rest of your evening.
Thank you.